Hey guys, today we get to talk about all things restrictive covenants, non-competes, non-solicitations, aka NDAs, aka trade secrets, aka employment contracts. Anyway, let's hop right in because there's a lot of stuff to cover, okay? Basically, every state has different laws as far as restrictive covenants go. All right, so some of them are very employee friendly. That means that it's going to be difficult for an employer to restrict an employee from competing with the company after they leave the company or if they're fired. So that includes if you're fired or if you quit, okay? All inclusive. Other states, such as Georgia, are much more favorable to the employer side if you quit or are fired and thereby leave the company. Okay, so if your state, you need to check it for your state, or if you want some help, give us a buzz. Depending on how favorable or not the state's laws are, okay, this is not a federal law thing, you may or may not have a restrictive covenant, aka non-compete, aka CNC, aka NDNC, aka like the names of these go on endlessly. There's two main ones that we really need to talk about. Non-solicitations and non-competes. These are actually quite different. So the biggest one that people get all up in a fuss about, which makes sense to me, if I were involved in one and not a business owner, I would have a fuss about it too. The biggest one is non-competes. So let's talk non-competes. Non-competes are when you restrict an employee's ability to work for another employer that is competing with you directly, okay? So what does this entail? There's a scope problem here, okay, because it's fuzzy. We don't know what scope that entails. So is it across the entire United States? Anybody who's competing with us? Hey, we've all got a website. Someone with a law firm website in, Kentucky might be competing with me in Georgia, but probably not, right? Most people in Kentucky are going to go to that one. Hey, Kentucky guys, give us a call though. We'd love to help. What's the geographic scope of that non-compete agreement? Usually courts will want to restrict it to about 50 miles. I've seen it as big as, a state or even the Northeast or the Southeast or something like that. Some states are bigger than others, so that means different things. It also kind of depends on the actual customers and people you're dealing with. If you have a business that has a really small circle of people around the globe, where it would be impossible for you not to compete if you were to continue anything with the people and the job that right? So, because it's such a small world in this niche market that you're in, that if you were to take another job with anybody else, it would automatically be with a competitor and it would be considered competing, right? So there can be a problem there. So you want to narrow the scope. The employee wants them to narrow the scope to like 10 or 20 miles from their principal place of business, okay? The employer wants to broaden the scope geographically to 50 or 100 miles or the whole Northeast or United States or the world, right? Okay, there's a scope of time. So most employer-friendly states, such as Georgia, allows for pretty much a set 2-year time limit. So for a full 24 months after the date of your last employee, which would be the date you were terminated or quit officially, after your 2 weeks is up, 2 weeks notice counts, you won't be able to do competitive activities, okay, on a non-compete. So there's a time scope, there's a geographic scope, and there's a sort of content scope. What constitutes competing activities, okay? So that we litigate these a lot because it's a really fuzzy sort of, standard, right? And nobody really knows. So we got to take it to the courts to really dish it out. So, is it a competing activity if somebody like from a law firm that worked for me moves to a CPA firm. I would not consider that a competing activity. However, they're utilizing a lot of the same clients, right? So a CPA firm's accountant's firm is going to be targeting a lot of the same clients as me. But that kind of gets into the non-solicitation thing, which we'll talk about in a bit. Not to confuse you, okay? But certainly if somebody is moving from, working for an airline to working for, a pet care company, that I don't think would be a competitive activity with their prior airline employer, right? So Delta employees should be just fine, to go work for, another company. And the reason why they don't want us to have these restrictive covenants is because it's a restraint on trade. So it, robs people of the ability to make their livelihood, okay? And we've litigated on both sides, the employer and the employee side, so I see both arguments. Okay, so that's all non-compete, okay? Then you get into non-solicitations. I should say with non-competes, though, that there's a lot of states that just carte blanche delete them. So even if you sign a non-compete in, say, California, California pretty much just nixes that whole thing and they won't allow it at all. And sometimes they even penalize the employer for trying. So, check out your state's laws or give us a holler and we'll help. Non-solicitations over here. Non-solicitations are different. It has to do with soliciting people, okay? So what kind of people? If you solicit customers, that's a solicitation, obviously, that they would care about. So if you quit, your law firm job and you wanted to solicit law firm clients, that might be a solicitation issue, okay? There's special rules for lawyers, but we don't need to get into that. If you solicited other employees at your prior company, that would be a solicitation that could be a problem, right? Because the employers has spent so much money investing in these employees and getting them all ready and up to snuff and trained and everything. So if you were to solicit them and say, hey, I'll give you a 5% raise if you work for me or this competitor, that would be a problem. So there's an ability for most states' laws for employers in most states to restrict their employees' abilities to solicit employees, to solicit customers, and to solicit vendors. So a lot of our value as companies is in our training with vendors. Vendors are sort of major employees. I might have a great marketing vendor, for example, and I don't want my employees to go to a competitor and take over all of my vendors because they know what great contracts I figured out and the training with the vendors and suppliers, manufacturers, things like that. So non-solicitation protects against soliciting. Usually non-solicitations are okay in most states. I'm not sure about California, but most states are employer friendly when it comes to non-solicitations. Non-competes is kind of a half and half type deal. Georgia's favorable to the employers, unfavorable to employees. California is the opposite, favorable to employees, unfavorable to employers. Okay, so how does this all flesh out if you've actually signed a non-compete or non-solicitation or restrictive covenant or AKA C&C blah, 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 right? Great question. So you need a lawyer to review it because we need to review it against the backdrop of the state's laws that apply. We need to review it against the backdrop of the circumstances. How long were you employed by them? What was the scope of the work you did for that employer? What was the factors when did you quit or were you fired? If you were fired, we might have some leverage, Maybe the fire was borderline discriminatory or actually discriminatory. What kind of competitor, if any, do you want to go work for? Is it a direct competitor that's right nearby? Is it somebody in another state? Is it somebody that does some of the similar type of stuff, but they could sort of, screen you from doing that? What are the circumstances, okay? So they need to analyze the contract that you signed against all the circumstances. Once we've hashed that out and sort of talked to you about your options, then we, decide whether or not we're going to bring this up to your prior employer. You don't always have to bring it up necessarily. Some of the contracts require that you do, and that's kind of another legal question if they can enforce that or not, because you're no longer paid by them, you're no longer employed, and you kind of just need to figure out, you need to weigh the pros and cons, okay? When it is worth it to bring it up to your prior employer, and or they're already sort of sending you threat letters and demand letters and cease and desist letters and things like that, then we need to, kind of circle back and basically negotiate with them. So some new employers love their new employees so much, they're such a benefit that they will buy out their non-compete from the prior employer, which is basically just, hey, I don't know if there's any, contract here or any right or wrong that anyone's done, but we want to settle this and continue to hire this person, for X amount. So we'll pay you this lump sum, or I don't know, payments over time. Other new employers, don't want to get involved, so they kind of just drop you and say, hey, you need to deal with it. If you can deal with it, then let us know. We'd love to have you, but we're not going to hire you if it's going to mean all of this junk that we have to deal with. From the employer side, it's really it's up to you. The employer, I'd say, has the majority of the power and incentive to restrict the prior employee's activities for the next year or two, depending on the contract they signed and, again, the circumstances. So if you're an employer and you're in this situation, or if your employment contracts don't have any of this stuff in there, let me know, because we definitely need to add them into your contracts, and then we need to just go over the circumstances with you and figure it out. I will say, though, that judges on the whole really hate restrictive covenants. So they won't really allow you to enforce non-compete, non-solicitation, non-disclosure type provisions unless you have it written into a contract in the first place. So what does that mean? That means that you have to have a lawyer write the contract with these covenants that are that work with the state's laws that you're in, that apply, and they have to sign them within, on the same day or within like a couple weeks of their employment start. Yes, you can add restrictive covenants in most states later on. So like halfway through their employment or something. We talked about this earlier. If you bonus somebody, that's a great time to link that bonus to a new contract for them to sign. But basically, if you don't have this in a signed, written contract, there is no way that you're going to get a judge to restrict their activities later on. So if you don't have this in the contract, really key employees can solicit all of your employees. They can solicit all of your customers and undercut costs. They can kind of Walmart you out. They can come up with their own business with, a different profit margin from yours and just sort of take over all your business. It's a scary thing that you should be concerned about as an employer. So I think that's everything. Restrictive covenants, non-competes, aka C&Cs, aka NDAs, aka non-solicitations, aka, the list goes on. But you got it. Keep rocking, guys. Give us a call if you ever have any questions. We'd love to help.